In the Idaho 4 case, Bryan Kohberger will never see the firing squad.
Why are you saying that? Do you have some points you're trying to make today? So what's this about Bryan Kohberger never being put in front of a firing squad? I'm Lainey Law.
And I'm attorney Andrew Myers. Yeah, we have a number of different reasons why I feel pretty solidly secure in my prediction that Bryan Kohberger will never, ever see a firing squad.
Why would you say that? So I guess one of the things that I'm wondering is that, one, are you implying that if he's found guilty that it's not going to happen?
Well, let's just take a look at the case. And here we have 11 reasons why he will never see the firing squad. And we have a little bit of background here. As you know, a lot of stuff has been redacted and sealed in this case. And one of the things that was redacted, 6 of the things of many that were redacted and sealed are shown right here. On May 31st of 2023, there were 6 orders to seal various material in this case. AT&T material that was obtained on warrant. The same with Google, Reddit. That's that survey that Kohberger had done, asking criminals, what was going through their minds when they're committing crimes. Snap, that's Snapchat. Strava, that's a sports documenting company. TikTok. And on May 31st, the court ordered all that stuff sealed. The bottom of each of those 6 orders said, as indicated right there on the lower right-hand side, it is hereby ordered that the record herein shall be disclosed except for the following. The affidavit in support of search warrant, sealed. The search warrant and receipt of inventory be redacted. This order will remain in effect until further order of the court, which, by the way, means nothing. But the funny thing is that, when those things were disappearing on order of the court, some other stuff disappeared also at the same time, but there was no order.
But why would that be significant? So I guess I'm curious because we've gone through, the Reddit, redacted, sealed. What makes the other stuff so different?
One of the things that disappeared at about that same time was an affidavit by the defense's investigator, Richard Battanti. This had been of record in the public docket in the Kohberger case. As you can see, it's captioned right there with the case number, State of Idaho versus Bryan Kohberger. And this was during the time that Bethany Funk was resisting the efforts to bring her to the out-of-state court in Idaho because she had moved to Nevada at that time. And this affidavit was somewhat controversial. It disappeared. Fortunately, we saved it before it disappeared. And it points out that Richard Battanti is a criminal investigator hired by the defense to assist in the representation of Bryan Kohberger. And it points out that at the time, Bethany Funk's bedroom was on the first floor. The other surviving roommates' bedrooms were on the second floor. That's Dylan Mortensen. Bethany Funk was interviewed by police on several occasions. She disclosed things she heard and things she saw. Bethany Funk was present at the home 8 hours later when police were called, arrived on the scene and discovered the homicides. And notably, during the course of the investigation, it became known to him that Bethany Funk has information material to the charges against Mr. Kohberger. Portions of the information Ms. Funk has is exculpatory to the defendant. Ms. Funk's information is unique to her experiences and cannot be provided by another witness. Now, you might ask me, this was some time ago. This is, a long time ago. But the thing is, this disappeared without any order, and this is exculpatory information. The other interesting thing, having read through most of this now, where does it say that Bethany Funk was actually home at the time of the crimes?
I guess that's a good point. Because we know that she was home 8 hours later, but it never specifies that she was there. And it's interesting, obviously, it focuses on Bethany and it doesn't even name Dylan, but you do have a point there. It never specifically says that she was at the house. It only mentions when she was there when the police arrived.
Now, maybe we're reading too much into this. We don't know. It's possible reading too much into that, but it's kind of interesting the way they worded that. It says Bethany Funk was present at the home 8 hours later when
Not
the
the
called.
did. Yeah.
That's really very strange that it says that to me, and it's also very strange to me that the other things that we just mentioned were taken off the court docket, but only on a court order. This, the affidavit in support of the motion for out-of-state service, the affidavit of Richard Battanti, just mysteriously disappeared, which, I'm not the only person that thinks that's just a little bit odd, don't you?
Yeah, I don't know. You would think that in order for something to go away, that it would have to have some kind of order. I'm surprised that it would just vanish like that.
And as I said, I'm not the only person that thinks that's just a little bit odd. Our friend over on the other side of the pond, Mr. Harsh, also had a strong opinion about this.
I don't know any other crime off the top of my head, certainly, where the surviving people in a mass murder inside a house has been treated with such kid gloves. Such kid gloves and protected. And I've also never seen a situation where James Fry, for instance, comes out and says that they are not witnesses. They are not witnesses. I never said they were witnesses. I said they were there. I didn't say they were witnesses. But then that completely turns around on its head, and all of a sudden you've got a witness there. And not only a witness, but the person who controls the entire narrative of this time frame.
So that's kind of interesting that, I'm not the only person that says it's kind of strange that disappeared, and that Ms. Funk and Miss Mortensen are being treated in that manner.
Yeah, I don't know. It's a little interesting to me. I mean, it does mention that there was 6 people in the residence, but it doesn't specify who. And it's interesting to me that that would just completely vanish without a trace and no actual record of it. If they were to throw something out, like if they decided that it was not an appropriate thing to have for the court case, wouldn't they have to be some kind of procedure for that as well?
One would think so. Yeah, absolutely. Let's move on to reason number 10 why Bryan Kohberger will never see a firing squad. And I've never really understood. Yes, I've read all the motions. I've read the 38 and 40-page explanations. I've read it all and done my research. Having said that, I still don't understand why they're fighting over the investigative genealogy material, because you know what? They should really just, if it really means nothing and it didn't go into making up the case as the prosecution says, why not just disclose it all? So here's just a brief summary of the history of the fight over the investigative genetic genealogy. Back on May 3rd of 2023, the Kohberger defense filed its third supplemental request for discovery, requesting information, including genetic genealogy testing and the research that was being done. And immediately 2 days later, the state responded. They pointed out, hey, we've already given you a ton of stuff, including 52 terabytes of stuff, but they objected to giving out the investigative genetic genealogy material.
It's like, you already have all the stuff you didn't ask for. Why do you want more?
Exactly. So they said, we gave you a lot of stuff and we don't want to give you the IgG. So June 22nd of 2023, the Kohberger defense filed 2 declarations of DNA experts supporting their third motion to compel. And we're going to take a look at that in a second. October 25th of 2023, there was a 32-page court order for an in-camera review of the IgG DNA. And what that means is the judge was going to accept everything, and decide in private in his office. That's what in camera means. He takes it into his own chambers, they call his office, take a look, and then decide, what would be allowable to be disclosed to the defense. And that came on November 8th. The judge ordered that the IgG be disclosed to the court only. Approximately 4 weeks later, the state gave notice of its IgG submission to the court. Now, this was over the holidays, and the court obviously has other things to do, but on January 11th, the court ordered the state to turn over a portion of the IgG information. After all of this, they say only a portion.
I'm curious as to what a portion even looks like in that situation.
Well, we really just, don't know. Now, I said we're going to take another look at this briefly. The defense, Bryan Kohberger's attorneys, put out a notice of filing a declaration of Bicca Barlow. Now, she is a DNA expert. And here's what they said in their filing, pointing out how important this IgG information is. Bicca Barlow, in her affidavit, points out that she's acted as DNA counsel or as a consultant on cases involving DNA expert in over 200 cases, including capital
Crazy.
cases in both trial and post-conviction proceedings. And she points out all the experience she has, going all the way back to the early 1990s and all the cases that she's worked on. And it's really quite impressive. And if anybody really wants to read it all, it is in the court docket. She points out in some cases, both law enforcement and genealogists that they have employed have engaged in deceptive practices, tricking family members, surreptitiously gathering genetic material from non-suspect family members, or simply uploading an evidentiary profile to a database that does not allow law enforcement searches. And she points out that it's imperative to the defense in this case to know how Mr. Kohberger was identified and who else in his family tree might have been identified as a subject of the investigation. So that's how the whole issue was supported early on, pointing out that the defense really should have a right to all that information. And Ms. Barlow concludes by saying the government's arguments are similar to those that were eventually discarded by courts when they recognized that the search of a database can be considered as relevant evidence. Research in the area of the impact of an IgG search on the statistical weight of a DNA comparison using standard STR DNA profiles is ongoing. And so, that was just kind of a warning way back at that time that this material is relevant and it should be discovered. So now we fast forward to February of 2024, and the state is still saying, look, we still think this is an issue. Here's a motion requesting clarification of the sealed order for disclosure of the IgG information. And the issue here was that the court had said that no individual on the family tree may be contacted by the defense or any agent of the defense without prior authorization from the court after a showing as to why such contact is necessary and material to the preparation of the defense. But the defense, it said, as part of its necessary work, has previously identified family members and work is being conducted. The defense does not expect to use the protected materials to identify people to contact without further order of the court. However, and this is a big but, the defense needs to continue its investigation with witnesses and resources generated from sources outside of the protected materials. Without worry, the plain language of the protective order could be interpreted to prevent that work. So the defense was seeking a clarification of the specific language in the court's protective order. What this tells me between the lines is that the defense is still working and talking to a lot of people, trying to identify witnesses. And what if they stumble upon somebody that's in this IgG initial search? What if they stumble upon somebody? Are they violating the court's order by talking to witnesses who just happen to be in that profile?
Mm-hmm.
And the prosecution didn't really object to it too much. They said that the defense experts or investigators should not be allowed to use the protected materials to identify individuals or witnesses to contact without prior authorization from the court, and after showing why the contact is necessary for the preparation of the defense. This would not prohibit the defense from contacting potential witnesses learned through sources outside of the protected information. So,
Okay. Because that's kind of what I was wondering is that, like, say they wanted to interview his dad, for example, prior to that, and then they got the IgG information, and then they still wanted to talk to him after that. So what that is saying is that if there was someone that they had previously already been speaking to, that getting the IgG information wouldn't stop them from speaking to that person, but that if they discovered someone new, then they can't contact that person without asking permission, at least.
I think that's a good question. I don't know if it would pertain to the father, but I think that's a really good question because, for example, they lived in a little town in the Poconos in Pennsylvania. There may be people that would be able to have some relevant information. We don't know who Mr. Kohberger talked to. We don't know what he might have said to people, but it's a relatively sparsely populated area in terms of the rest of Pennsylvania. And what if they stumble onto a witness who might have heard some things that Mr. Kohberger might have made some admissions to, and they happen to be in that IGG search list? So good question. And it remains to be answered. And the court is going to have a hearing. But I mean, the point here is that this IGG search has been going on. I mean, this issue has been going on and on and on. My position is just give it to the defense, not disclose publicly at this time. Just give it all to the defense. And if it's really nothing, if it's a nothing burger, I love that word. If it's a nothing burger, according to the prosecution, let the defense have it. Don't disclose it publicly. Let the defense have it and waste their time as long as they're going through the 51 terabytes. So I've never understood why that has continued to be such a huge, crazy issue. So now we get to the heart of the matter. Ex post facto laws, which we all learned about in civics class, I hope, say that a law cannot apply retroactively. In other words, if you do something on day 1 and the legislature makes it illegal on day 5, they can't retroactively go back and make that illegal. Well, guess what? That also applies to punishments. Article 1, Section 9 of the United States Constitution declares that no state shall pass any ex post facto law. And that's also in the Idaho State Constitution, Article 1, Section 16. Interestingly, it doesn't just apply to the substantive law, it also applies to punishments. And here's a quote from the United States Supreme Court. It's an old case, but it's still good law. Any law which was passed after the commission of the offense for which the party is being tried is an ex post facto law when it inflicts a greater punishment than the law annexed to the crime at the time it was committed. So let's remember that the Idaho 4 horrible crimes were committed early in the morning on November 13th of 2022. Well, the Idaho legislature passed the firing squad law on March 20th of 2023, and the governor subsequently signed it. And I certainly would contend that where Idaho's death penalty previously encompassed the lethal injection that includes 2 injections, the first injection pretty much puts the person to sleep, anesthetizes them, so to speak. And then after they are asleep, then they get the second injection, which terminates their life. I would certainly contend that putting people in front of a firing squad, is much more onerous than that and fits the definition of a greater punishment. And so therefore, it's unconstitutional. So that's why I say whether anyone is convicted or not for a crime that occurred before the firing squad legislation went into effect, they're not going to go in front of a firing squad.
And I think that's a very valid point. And I think that, like you mentioned, is like if I'm the attorney, the defense, I think that's something that I would definitely argue for. I mean, obviously, I'm not a legal professional, so, but
Well, you're right on point, though. Yeah, right on point.
But it's like even like beyond that, I think another thing, it's like there's this, and there's also just the fact that they've been having such trouble in discovery, where they're really, the prosecution is just setting themselves up to have this issue later down the line, where it's just like now it can be debated if the defense was even able to do their job properly. And here we are, going to be 20 years later, and this is still going to be an argument potentially, depending how this goes.
That's right. That's right. Okay, let's go to reason number 8 that Mr. Kohberger will never go in front of a firing squad.
We have lingering questions. So is it 1 suspect, 2 suspects, multiple suspects? And that's something in our comment section that we have a lot of people that wonder about that, because a lot of people are like, oh, it was him, it was only one person. Oh, it was 2 people, it had to be 2 people. How could one person do that themselves? Or, oh, it was the whole cartel. The cartel came and took care of it. And a big thing of the contention between 1 or more suspects that a lot of people argue is, how can one person get this all done? And a lot of people are saying, well, if there were multiple people, then, one of them is going to snitch on the other. So it's messy, definitely
Who knows?
messy.
Yeah, who
Yeah.
knows? I mean, I've from the very beginning, as you know, I've never believed it was one person. People argue with me and say, "Oh, yeah, Ted Bundy went into the sorority and all these other things." BTK took care of 4 people in his first crime, but the way that this crime was committed, the manner in which it was committed, I don't believe it. I don't believe it was one person. And you know what? Just this morning, the day that we're recording this, an old friend of mine came in, somebody I hadn't seen for years and years and years, just happened to come into my office to talk to me. This case came up and I didn't say a word about the case. And she said to me, I don't believe that one person did all that. I don't believe one person did. So, these are people that are out there in the public, and the jury will be drawn from the public. So that's reason
Mhm.
number 8. Reason number 7 as to why Mr. Kohberger will never appear before a firing squad.
No cast data. So the FBI Cellular Analysis Survey team, those are the ones that analyze the cell phone provider data, and they'll be the ones that give the tower info and location data. And this has been another issue that has been going on with this case and the defense being able to get this kind of information from them, which is crazy. I mean, if it's the stuff that's incriminating him, you would think that that's something that they would have access to.
This is really mystifying because going back to the initial probable cause affidavit, they said that they saw the Kohberger car driving around 12 times in the months before the crimes. And the night of the crimes, he was tracked on this street and that area and the other regional area. And so if they've got him, and they know that, his Hyundai Elantra model year 2015 was it, why don't they give that stuff over? But as recently, now we don't know, maybe by the time we drop this episode, it'll be provided. We don't know. I doubt it. But as recently as the hearing in late January of 2024, that cast data had not been provided to the defense. And as you know, in the Alexander Murdoch trial, that cast data from the FBI was really an extremely, blockbuster material that really nailed him. So the 6th reason why Mr. Kohberger will not ever face a firing squad, we're now on the 11th round of discovery. This is the 11th supplemental request for discovery. What is the prosecution hiding? What are they holding back? I mean, a lot of people say, they were gung-ho on, they initially wanted to try this case and they were going to be ready to try this case in June of 2024. If they're ready to try the case and they have such a strong case, and a lot of people in our comment section feel that, the prosecution has Mr. Kohberger nailed, then why are they holding back on the discovery? Just give it all up. No sense to me.
Mhm.
Makes no sense to me.
Yeah.
Reason number 5, and this is a really interesting one. It's been out there for a while, and I'll acknowledge, we talked about this some time ago, but if Mr. Kohberger was a criminology student and a PhD candidate, which he was, and if one of his undergraduate degrees was in cloud-based forensics, and if, as some have said, that he was a meticulous control freak, then let's think about this. Wouldn't he have planned the perfect crime? Wouldn't he have planned the perfect crime? And not to dwell on this, because we've talked about this before, and a lot of other people have commented on it before, but if you really think about it, would he have taken his own cell phone that night? And would
That's
he have turned? Go
yeah.
ahead. Yeah. What were
Well,
you
I
going to
was gonna
say?
say, just like at the end of the day, it's just like, leave your phone at home and take an Uber, I
But he
mean,
took
maybe
his
not
own.
take an Uber because that leaves a phone trail, but still,
No,
it's
you're
like,
right. He took his
yeah.
own car. He took his own car registered to him in his name, which at that time had the Pennsylvania license plate. He turned
Mhm.
his phone off at exactly the time that the crimes were committed. He allegedly, purportedly, is said to have left the sheath of the what we think might possibly be the murder weapon. Really? And then after that, there was the whole Papa Roger thing where he was talking about the crimes afterwards, supposedly. So, I mean, if he was this brilliant guy that was wanted way out in Washington State to be a teacher's assistant, why would it doesn't make any sense? And you know what? I'm speechless. But if you want a really good, what gave me the idea for number 5 here was I was watching a podcast by a guy by the name of A.R. Hayes, and he goes into detail on how to plan a perfect crime. And Kohberger didn't. He got an F on that.
No, that's one of the things that I'm thinking too is like a lot of people that watch our podcast and watch true crime stuff. It's like they, obviously, I think most of them have no intention of ever murdering someone, but a lot of us will be like, oh, like if I was going to do the crime, I would do it this way. They got caught that way. You would think
Right.
that someone with more experience who is a criminology student would have thought a little bit more in depth over all these things that, normal civilians are even aware of.
Yeah, I've tried a bunch of cases, and before you try a case, you do a lot of planning. You do a ton of planning. You know about this witness. You know about this photograph. You understand this argument that they're going to make that could potentially sink your case, and so you spend a lot of time thinking about how you're going to deal with all of these issues. That's what I know in my profession. I'm not a criminal, but if someone is a criminal, this guy A.R. Hayes really dug really deeply into this subject and gave a really good argument. I know we've talked about this before, but this guy really inspired me to bring this up as reason number 5. Reason number 4 that Mr. Kohberger will never see a firing squad is just these timelines. They're crazy. The coroner, Kathy Mabott, said that it was sometime after 2 a.m. The probable cause affidavit in a previous episode, we dug into this pretty deeply. At one point, the probable cause affidavit says that the homicides occurred between 4 a.m. and 4:25 a.m. But then 4 minutes later, suspect vehicle 1 is making a 3-point turn. So how could the homicides start happening at 4 o'clock, but then the suspect vehicle is making a 3-point turn, and then suspect vehicle 1 departs the area at 4:20, but the crime continued until 4:25? Huh? What?
Mhm.
And one of the parents, I forget which one of the parents said that 2 o'clock will always be a difficult time for them. So someone told somebody that 2 o'clock was the time. So was it 2? Was it 4? Was it 4:04? Was it 4:17? Was it so they've got a lot of splaining to do on these timelines, and there's already an affidavit that states when it happened. And so if that's not when it happened, someone's going to be cross-examined quite a bit.
Yeah, I definitely agree with that. The timeline is absolutely bonkers.
Yeah.
All right. So about that alibi for number 3 over here, we have Mr. Kohberger has long had a habit of going for drives alone. Often he would go for drives at night. He did so late on November 12th and into November 13th, 2022. He was out driving during the late night and early morning hours of November 12th to 13th, 2022. And that was the Kohberger filing August 2nd, 2023. And something interesting about this too, like we talked about before, where it's just like if he's supposed to be so meticulous and have this all planned out, wouldn't you think he would have a better alibi? Wouldn't you leave your phone at home? Wouldn't you be sleeping at home, driving out? Oh, I was just driving around, that's very incriminating. So it doesn't make sense that that's not something that would have been planned in advance, I think, personally.
Well, yeah. When I first saw this, like most other people, I said, this is balderdash or something else that's BS. And it's really,
Mhm.
no, that's not an alibi. That was my initial thought. And 2 things. The first thing is I actually offline, and I didn't record the interview. I should have, but one day when we were preparing for a different episode, I spoke to someone who had gone to school out in that area and knew that area really, really well. And she told me, and if she's out there watching this podcast, call me back and we'll put you on. I promise. I wish I had put you on then, but she said this is a thing young people do in that area because unless you're really into the studenty activities, or unless you're one of the cliquey people that goes to these parties, there's really nothing to do in those towns late at night. There's really, those towns, it's just they roll up the sidewalks. And then, like I said, unless you're one of the cliquey people that goes to all those parties, or unless you want to go to one of the school activities, which end pretty early in the evening, she said that she drives around at night and listens to music because, when she lived in a dorm, unless you wanted to listen to all the other kids playing their music loud, she would get in her car and blast the stereo and drive around. So like I said, when I first heard this alibi, I thought this is total rubbish. But then I
Yeah.
talked to her and this percolated through. And then a memory came to me. A memory came to me of one time I was like 17 years old. I think I was 17 years old. And I don't even remember what had happened. I don't remember what the trigger was. I got in my car and I drove. And I drove. And I drove. And Mom and Dad, you're not here anymore. And you don't even know this. I never told either one of you, but my parents were divorced at that time and living apart. And I disappeared. And even though they were divorced, they called each other. Where's Andy? I don't know. Is he with you? No, he's not with me. Is he with you? No, he's not with me. And they called the few friends I had at that time. I wasn't anywhere. I'd gone. I disappeared off the face of the earth. I got in my car and I drove and I drove and I drove and I drove some more aimlessly. And I appeared all of a sudden in the city streets of Philadelphia, which was about an hour and a half or so in the back roads from my house. So I drove around Philadelphia. I went to the train station. This will show you how old I am. If anybody is watching and they're from that area, I picked up a copy of Thursday's Drummer newspaper. And I got a soft pretzel, the likes of which you can't get anywhere except in Philadelphia. And I got back in my car and I aimlessly drove around a little bit more through Chester, Pennsylvania and Gap, Pennsylvania, until I finally got home. So I drove aimlessly for a whole night. Now, God forbid some horrible murder had happened while I was driving around. I had no alibi, and nobody has an alibi in the middle of the night if they go to bed at, say, 10:30, 11 o'clock, and then they don't get up till, what's your alibi? So I don't know. I'm not saying I fully buy this, but it is a thing I'm told. I'm told. And if that person wants to call me back, we'll put her on. In that area of the country, there's nothing to do late at night. So
I definitely believe it. I've definitely had similar situations with you where it's just like, just go out for a drive. Even now, a lot of people think that like, oh, you're bored, you stay home on TikTok, but some people don't like social media. Some people want to drive. Some people sing in the car,
Yeah. Yeah, exactly.
Mhm.
Okay. Number two, who was in charge of this investigation? If you look at the probable cause affidavit, the crimes happened between 4 and 4:30, according to that affidavit. Moscow police officer Brett Payne arrived on scene at approximately 4 o'clock in the afternoon, 12 hours later. And the affidavit said that upon arrival, the Idaho State Police forensic team was on scene and was preparing to begin processing the scene. Wait, what? Who's in charge here? Is it the Moscow Police Department or is it the Idaho State Police forensics team? So now to confuse matters even more, if you look at the Pennsylvania affidavit of probable cause, and here it is, it's the actual affidavit of probable cause in Pennsylvania. It's not Exhibit A, it's the affidavit of probable cause. And what it says is, we were requested to assist the Moscow Police Department, Moscow, Idaho, and the Federal Bureau of Investigation. Wait a minute. Who was the primary agent in charge of that site? Standard protocol that if there's a crime of this magnitude, any crime really, but a crime of this magnitude, there is one central agent. There's one person that's responsible for that scene. Arriving officers seal it off, put the tape around, throw everyone out. Nothing happens until the principal agent gets there, whether it's Moscow police, whether it's FBI, whether it's ISP, whether it's little green men that come down from Mars. One person is in charge of that investigation. So, Mr. Myers, how is this relevant? I'll tell you how it's relevant. The way it's relevant is that on cross-examination, these guys are going to have a hard time saying, well, Dick was over there walking through the first floor and Harry was upstairs in well, who was telling Dick and Harry what to do? Who had the central responsibility for nailing the scene down and preserving it and then processing the evidence correctly.
Are you
And
trying to tell me that when there's a scene of a crime, we can't just all do what we want willy-nilly and everybody just tries to do different things?
yeah, that sounds good. And then to complicate matters even more in doing my research, as our commenters love to say, do your research. In doing my research on primary responsibility, in Idaho, there's actually a state law that says anytime there's a crime, it's the county that has primary responsibility for taking care of that crime in Idaho. So
Mm.
the question remains, who was in charge, who is in charge at trial when questions are asked about processing of the crime scene? Are people going to say, well, it was it was her responsibility there. She did it. So, I don't know. So
Mhm.
the number one, there are a ton of reasons, but these are the only ones I had time to make slides for.
The jury verdict must be unanimous. It takes only one holdout. And I think, judging by our comment section that's filled with normal everyday people, of which, the type of person that the jury would be selected, nobody can agree on any of this. And it only takes one person.
No, that's right. And like I said, somebody that walked in the door of my office today, before we recorded this podcast, came in without even saying anything. She said to me, I'll never believe one person did that. So all these people, all these thoughts are out there. These are all legitimate things that people talk about. If you want a bonus, and again, we could have done 1,000 of these, but you could go to a webpage for the Idaho Innocence Project, and it will tell you about capital murder cases in Idaho that have been overturned. People that have gone to jail, found guilty in Idaho of capital crimes. And then the Idaho Innocence Project has found that they were innocent. So we could go on. We have one more bonus. And that is people have accused us of beating a dead horse. And it's true that we have talked about some of these things in the past, and we know others have talked about some of these things in the past, but the horse is alive and well and trotting around the stable, because until this case is tried and until these questions are answered, the horse is alive and well and kicking and eating its straw. And I want to thank my friend Sarah for sending me the picture of the
We love it.
horse.
The horse is alive. The horse is healthy. There's more to find out about the horse, folks.
And as we all know, a horse is a horse, of course, right?
Of course, of course.
Now, we didn't talk about this before we turned on the machines. Are we going to do comments today or not?
I didn't have any prepared, but if you wanted to read some, we can.
Okay. Bethany Funk. Bethany Funk will probably prove to be a huge problem for the prosecution. She has already made several statements to the police, which are undoubtedly on record. If she tries to change her story, it could open her up for serious cross-examination. I firmly believe the prosecution went ahead with the grand jury to avoid the defense questioning Bethany. This is Ken Bash who commented, and we thank Ken for his comments. I just want to point out to people that we love our comments. We love the fact that you're out there challenging us sometimes, contributing new thoughts. I would just ask that people be polite, people be respectful, people, treat it as the serious thing that it is. We try. No, we make light sometimes, and people have commented, this is a serious case. How can you possibly make light of it? And we're sensitive to that. But in your comments, please remember, we try to be professional. We try and be respectful of each other's opinions. If you're just going to bash someone or something, that comment might have a problem.
Yeah, we appreciate contribution to the conversation. If you don't have anything nice to say, maybe don't say anything at all.
Yeah. So, any other closing thoughts, Lainey?
No, thank you guys so much for watching up until this point. It's been fun as always. Remind us and let us know if you have any other cases you would like us to talk about. And like you mentioned, like what the commenter said. It's just, I think Bethany does have a pretty important role in this. I can understand some hesitancy of wanting to get involved, but it's going to be exciting. Well, unfortunately, I don't want to say exciting. I don't know if exciting is the right word, but definitely interesting to see where this case goes.
Absolutely. And there's another hearing coming up in which a trial date may or may not be set. So
Ooh.
with that, thanks a lot for viewing. Be sure to comment and like, subscribe, and share. So with that, have a good one. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
That's that.
And that's that.
Live horses.
That horse came from a tunnel.
No tunnels.
That horse came up through a tunnel.
No tunnels. No tunnels, no calls, no dead horses.
Oh, there are tunnels.